Espaces Franklin LLC and Espaces Knoxville LLC. I'd like to reserve 5 minutes for rebuttal.
5 minutes, yes, sir.
Thank you. I'd like to begin by making two general points about this case. The first is that the Espaces company's position is not that they have no obligations at all to Mr. Wilt. Our position is that we don't have contractual obligations arising from a severance agreement that the parties tried to negotiate, but as to which they didn't reach agreement on all essential terms. The expenditures that Mr. Wilt made on behalf of the Franklin and Knoxville projects were to be treated as early investments. They were to be recognized when the project's funded by either Mr. Wilt being paid back with interest or being given an equity interest in the projects. And Mr. Wilt recognized this in his deposition testimony. He testified, I felt, if I'm going to act as CEO, I need to put a whole lot of skin in the game. And I took a personal line of credit out to write that check. So Mr. Wilt had skin in the game. Conversely, on the other side of it, the Espaces companies had obligations to recognize those interests at the appropriate time. The second general point I want to make is this. This is Mr. Wilt's memorandum in support of his summary judgment motion that was filed with the trial court. It's 5 pages, including the certificate of service, signature lines, caption. It's really 3 substantive pages. Statement of undisputed facts, there were 8 of them. This is Mr. Wilt's response brief in this court, 62 pages, about 50 pages of substantive content. At every stage of the litigation of this summary judgment motion, Mr. Wilt has attempted to expand his theory of the case, expand the facts being presented to the point where in this response brief there's 40 citations to Mr. Wilt's own deposition, which were not relied on in the original motion. So I just want to ask the court to limit its review to the basis of the motion, which basically were what we've called the Wilt memorandum, which is the memorandum that Mr. Wilt sent on May 8th, had the signature line for Mr. Gibbs. What we've called the Gibbs email, which was the response to that memorandum, sent the next day. And Mr. Wilt also relied on some testimony from David Gibbs, who was chairman of the board of Espaces, Inc. That's really the legitimate basis of the motion. Now the main issue presented by the case is whether these parties entered into an enforceable contract. And there's 2 subsidiary issues. Was there offer and acceptance? And if so, they have to have both. If so, did the parties agree on all essential terms? With respect to offer and acceptance, as I said, Mr. Wilt relied on the Wilt memorandum and the Gibbs email and testimony of Mr. Wilt. The trial court really relied more on Mr. Gibbs' deposition testimony. In its memorandum, the court said, Mr. Gibbs admitted in his deposition that an agreement by defendants to pay the amounts claimed was reached. This evidence eliminates the need for a jury trial. In a reply brief, let me start here. The memorandum doesn't specifically identify the testimony that the trial court is relying on, but on page 50 of his response brief, Mr. Wilt cites to the deposition testimony that he thinks supports that holding. And in our reply brief, we go through that testimony, and it really falls into 2 different categories. One is Mr. Gibbs acknowledging the Espaces companies have obligations to Mr. Wilt based on the expenditures that he made. And as I said when I started this argument, we don't dispute that there are obligations. We dispute that there are obligations arising from a severance agreement. And all of Mr. Gibbs' testimony is consistent with that theory of the case. The company has obligations based on the investments. The second category of testimony that Mr. Wilt says the trial court relied on is testimony that some Espaces company, it's not clear what, intended to or agreed to pay or repay Mr. Wilt for the expenditures that he made. Again, this is consistent with our theory of the case. the parties had a problem. Mr. Wilt was terminated. He had these investments, and the parties needed to figure, they preferred to just sever relations. So they agreed in principle, Espaces Inc. would buy out these investments. And Mr. Gibbs acknowledged that in his deposition. He intended to have Mr. Wilt repaid. He wanted to have him repaid. He agreed to have him repaid. But it wasn't a specific contractual obligation acceptance of, a due date, amounts, who the payee would be. We cite the Jamestown on Signal case, which holds that mere expression of intent or a general willingness to do something is not an offer. I think the same applies to an acceptance. General willingness to repay the investments is not enough to create a contract. It's like if I ask my neighbor if I can borrow $500, and my neighbor says yes, we don't have an enforceable contract. We don't have repayment terms. Is there an interest rate? When is the $500 going to be made available? But if you put my neighbor under oath and ask, did you agree to loan Mr. Knight $500, I think the answer would be yes. And that's all that Mr. Gibbs' testimony establishes. They wanted to repay it. They just didn't get the funding that was expected. The other main issue is whether there was agreement of all essential terms. And I want to focus on 3 of them. One is there was no agreement on who even were the parties to this severance agreement. The complaint alleges, and the trial court found, that Espaces Inc. owed for expenses, Espaces Franklin owed a particular amount based on expenditures for that project, Espaces Knoxville owed a particular amount. But there's nothing in the parties' communications that identifies even that Espaces Knoxville, for example, is even a party to any agreement. There's no discussion of it at all.
But didn't all of the Espaces fall under one umbrella, one corporate umbrella?
Well, so Espaces Inc. at the time was, I believe, the sole member, but at least controlled the LLCs. So they were all related companies, certainly. But as this case demonstrates, the investors in the projects could be different. So, for example, it makes a difference whether Espaces Inc. owes money to Mr. Wilt or whether Espaces Franklin owes money to Mr. Wilt. Espaces Franklin may go out of business. It may be insolvent. Is Espaces Inc. obligated to make that payment? That's an important consideration. Or if you're an investor in Espaces Knoxville, it's important to you whether this is an obligation of Espaces Knoxville or Espaces Inc.
Are the judgments in favor of Mr. Wilt against all 3 entities or individually?
It's individually, and that's another important point, Your Honor. Mr. Wilt's theory could have been everybody is jointly and severally liable. The communications between the parties don't establish that, but that wasn't the allegation. The allegation was it was split up severally, and that was the trial court's ruling. Was
Mr. Gibbs the officer or managing agent for each of the 3, or authorized to speak and obligate each of the 3?
So we haven't contested that. There's some question about that we thought about whether to raise that issue. He was chairman of the board, and the parties acted as though he had authority. I think there really is some question about that, but we haven't raised that in fairness as an issue. Another essential term that wasn't agreed to is a payment due date, and that's really where this whole controversy arises from. Is Mr. Wilt says I should have been paid by May 18th, and the Espaces company said, well, we were going to pay when we got funding. We didn't get funding, and we discuss in our briefs the restatement of contracts that says when the actual source of the controversy is a term that a party alleges was not agreed to, it's more likely and more reasonable to consider that an essential term. And in this case, certainly it is. That's what gave rise to the controversy. I mean, if Espaces is right, they haven't breached the contract because they don't have to pay until they have the funding to pay. That, by the way, is the whole reason Mr. Wilt made these expenditures, because Espaces didn't have the money. So Mr. Wilt was fully aware of that. And I want to, while I just have a few seconds left, to raised a third essential term or set of essential terms. Mr. Wilt admits in his response brief that the parties didn't agree to his termination date and his severance payment at the time of the Wilt memorandum and the Gibbs email. He says that was agreed to on June 4th. Well, June 4th is more than 2 weeks after he says that the Espaces companies were obligated to repay him. So his theory is that they finalized a contract under which they had defaulted 2 weeks before. You know, it just doesn't make any sense. This is a summary judgment motion. If you look at the facts in the light most favorable to the Espaces companies, there's no basis for summary
All right,
judgment.
thank you, Mr. Knight. We'll hear from you again on rebuttal. The appellee. Good morning, sir.
Morning, Your Honor. May it please the Court, Nicholas Bolso, here for the plaintiff appellee, Toby S. Wilt, Jr. The plaintiff has argued from the very beginning that this is a remarkably simple case. The plaintiff, while he was CEO of Espaces, advanced $52,669.58 to Espaces Knoxville LLC so it could pay a lease deposit. He advanced $200,000 to Espaces Franklin LLC so it could pay off subcontractors who were threatening to sue the company, and then $20,298.84 to Espaces Inc. in reimbursable expenses. Now, the defendants concede that Mr. Wilt advanced those amounts to these entities. The relationship went south, and then during a lunch at the Jason's Deli in Brentwood, Tennessee on May the 8th of 2020, the plaintiff and Mr. Gibbs, who was acting for these entities, agreed on 2 points. One, Mr. Wilt was going to resign as CEO of Espaces. And point number two, the defendants would repay him the amounts that he advanced to these entities. Mr. Gibbs then, in his deposition, admitted to agreeing to repay those amounts, and then the emails the parties exchanged afterward further solidify that agreement. But the defendants never repaid Mr. Wilt, despite Mr. Wilt holding up his end of the bargain and resigning as CEO. Why? The defendants have said, or Mr. Gibbs has said, that they simply didn't have the money. They seem to agree that they have to repay Mr. Wilt at some point, but there's some wavering in terms of when they're actually going to have to pay this amount back. At this point, they are determined to delay repaying Mr. Wilt as long as possible until some unspecified indefinite date. We tend to agree with the Court of Appeals in Cameron General Contractors Inc. versus Kingston Pike LLC when it said that delaying performance like that into the indefinite future is ludicrous because that undermines the agreement itself. We also agree with the trial court that given the undisputed facts of record, given Mr. Gibbs' admissions during his deposition and given these emails that they exchanged, that there's really only one conclusion that can be drawn from these, and that's that Mr. Gibbs, on behalf of these entities, agreed to repay to Mr. Wilt the amounts Mr. Wilt advanced to the entities. The defendants naturally are trying to escape liability for that. The first argument they make is based on what they call the mirror image rule. As I understand it, the defendants argue that the Wilt memorandum, that is the memorandum that Mr. Wilt sent to Mr. Gibbs after this lunch at Jason's Deli, recapping the agreement they reached, was really just an offer that Mr. Gibbs then did not accept. The plaintiff, as I just stated, argues that that memorandum is actually capturing the agreement they reached at Jason's Deli and then adding some details to it. That's because when Mr. Gibbs summoned Mr. Wilt to this meeting, Mr. Wilt did not know he was about to get fired as CEO. He didn't come in prepared to go over their accounts and really establish all the amounts due. But when the conversation got underway, he realized what was happening, and that's when he extracted this promise of repayment from Mr. Gibbs.
Did the promise say how or when Mr. Wilt would be repaid?
At the Jason's Deli lunch, I can say I don't know. The parties have not discussed explicitly what they agreed to at that lunch. What we would rely on, though, is their emails afterwards fleshing out or telling us what they agreed to. And so...
and in essence, what do those subsequent emails say as to how and when to repay?
The first email was from Mr. Gibbs that followed on May the 8th at 3:35 p.m. He 3:38 p.m., he emailed Mr. Wilt, and he said, and I quote here, "I will take care of making sure that all company obligations owed to you are well understood, documented as necessary or desirable, and that those obligations are repaid as soon as possible." That email continues, "You agreed to provide me a list of those obligations so that we can be sure we have everything in one place. I expect funds to be available for this purpose by the end of the day, Monday, May 18th at the latest, and will confirm and let you know of any change in schedule as soon as possible. If the funds are available sooner, I will let you know that also and assure you we will take care of all obligations to you at the earliest possible date." Mr. Wilt followed that up with his memorandum later on that day at May 8th at 11:36 p.m. Mr. Wilt was a little more specific. In his memorandum, he has a heading, and it reads, "Financial obligations to be reimbursed to me in full by May 22nd, 2020. Those obligations were, of course, as he wrote them in the memorandum, Knoxville Espaces lease security deposit, Franklin Espaces demand note, and then payment of expenses totaling $20,209.84. So Mr. Gibbs is coming in saying, we'll pay you everything by May 18th. Mr. Wilt is saying, that's okay. I want to give you my 2 weeks notice. Pay me back by May 22nd. Mr. Gibbs responds the next morning, this is now May 9th, 2020, at 5:35 a.m., and he says, "The company's obligations to you will be addressed as you have outlined them here." The defendants seem to indicate that that phrase is confusing. We asked Mr. Gibbs what exactly he meant when he said the company's obligations. That picks up in his deposition on page 21. He admits that he's referencing these obligations that are contained in the memorandum. We asked him, well, okay, when you said, "will be addressed as you've outlined them here," what are you referencing? He said, "I'm referring to the memorandum and how Mr. Wilt has laid out these items getting repaid." Going back to the dates, Mr. Gibbs pushed back on that May 22nd date. His email there read, "I really think May 22nd extends the process longer than it should be." Mr. Wilt then replied again later that day at 10:27 a.m., agreeing to this new May 18th date, saying, "That's fine, I was just trying to give you 2 weeks, my 2 weeks notice, it's customary, we don't have to do that. If you want to pay me back earlier, pay me back sooner, that's fine with me." And all of that, there's also this underlying current of Mr. Wilt's severance payment, which the defendants bring up quite a bit. In his initial email back on May the 8th, Mr. Gibbs says, "You can have 30 days. Mr. Wilt then argues that he should get 60 days given the COVID pandemic and how everything's played out and how it's affecting him. Mr. Gibbs stays strong on 30 days and said that's our best offer. And so Mr. Gibbs then told Mr. Wilt in his May 9th email, this is at 12 p.m. that day, "The 7% interest on your loans and the Knoxville deposit is designed to compensate you for your risk." That's significant because the defendants argue at different points that we don't know what the exact obligations were. But again, we have here in an email, Mr. Gibbs is revealing that they agreed to 7% interest.
Mr. Bull, so let's back up for just a second. I want to make sure I'm understanding what you're arguing here. And if I understand your argument, you're essentially saying that the May 9th email from Mr. Gibbs, which I think was sometime around 5 a.m. in the morning, where he said, "We will address the obligations as you have outlined in your previous email," something to that effect. I'm summarizing, obviously not directly quoting. You assert that that was an acceptance of the obligations as being due and payable and also in the correct amounts? Is that what you are arguing here?
Our argument is that the parties reached an agreement at Jason's Deli on May the 8th that the entities were going to repay these amounts, but they didn't have the exact numbers before them. Mr. Gibbs had Mr. Wilt give him these numbers so they could actually get everything in one place. That's what the May 9th email from Mr. Gibbs is doing. He's acknowledging that Mr. Wilt has given him the numbers and confirming that those are the amounts that they're going to pay. But that's all developing or finalizing, giving the specifics to this agreement reached on May the 8th at Jason's Deli.
So May the 9th's email would be essentially his agreement to the amounts themselves. according to your argument then?
Is ratification of the agreement and acknowledging the numbers, agreeing to the numbers, yes.
All right, thank you.
To touch on just one final point on this issue of the severance payment, time goes by and Mr. Wilt is asking, he sends multiple emails to Mr. Gibbs saying, well, why haven't you repaid me yet? And finally on June the 4th, he says, I'm coming up on the last weeks of the 30 weeks of severance pay you gave me. And so we don't look to that June 4th date as a date of agreement on anything. That's again, that email is revealing that the parties previously agreed to 30 days, which is now coming due. But all of this factors in, Your Honors, because when we're looking to see if there's an enforceable agreement, we look, as the Court of Appeals held in Toby, HCA Health Services of Tennessee, we look for a meeting of the minds and mutual agreement to the terms. And what we have, as the court in Moody Realty Company describes it, we have these outward manifestations of the agreement that was reached. That's all these emails we have. It's also the admissions we procured during the deposition of Mr. Gibbs. But all of that shows that on May the 8th, we have this agreement to repay Mr. Wilt, and then on May the 9th, we're fleshing out all the details. We have those 2 dates. That's when the agreement's finalized, all the terms are known, and we have this mutual understanding between the parties as to what's going to happen going forward. The second argument that the appellants present is that the parties did not agree on all of the essential terms. We've noted in our briefing that, according to the Court of Appeals in Gurley versus King, that the destruction of a contract because of uncertainty is disfavored. As a matter of fact, it's strongly disfavored, and that's especially true where one party of the agreement has already performed, as Mr. Wilt did here. But even going to the terms that they bring up, we respectfully submit that the parties agreed to all of these terms. The first one is the parties to the agreement. The memorandum does not use the precise language that Espaces Knoxville LLC must repay Espaces Knoxville's lease deposit. It doesn't say Espaces Franklin LLC must repay the $200,000 that Mr. Wilt loaned to Espaces Franklin. And the reason it doesn't say that is because when Mr. Wilt and Mr. Gibbs are speaking, they refer to Espaces generally. They're not referring to one of the specific entities because they treat the company as a whole. And that's very common. That's their course of dealings. That's how they refer to the company in general. And even then, we go back to Mr. Gibbs's May the 9th email. He said, the company's obligations to you will be addressed. I mean, he says, when he uses the word companies, that's the singular possessive. He's just referring to the company and then the company's obligations. He doesn't use the plural possessive, the companies.
Which company deposited, I think it's 2 checks that your client wrote that are at issue, the $200,000 and another $85,000 or so. Which of the E-Space companies deposited the check? Is that a fact in the record, I guess, is a better question.
My understanding is that for Espaces Knoxville, that was the lease security deposit. I think Mr. Wilt wrote a check to Espaces Knoxville LLC. Espaces Knoxville deposited that and then paid its lease deposit. With Espaces Franklin LLC, that was a line of credit that Mr. Wilt took out. And then he paid $200,000 from that to Espaces Franklin, and then Espaces Franklin dispersed that amount to contractors and subcontractors who had worked on the project.
But the judgment in this case, is it against all 3 companies or just the E-Spaces Inc.?
The judgment is against Espaces Knoxville for its amount, Espaces Franklin for the $20,000, Espaces Inc. for the expenses.
Thank you.
The defendants also argue that it's not clear what the obligations are here, and that's likely because there is discussion in the memorandum between Mr. Wilt receiving an equity interest or 7% interest on the loans. What happens invariably in all of that, though, is that Mr. Wilt's being repaid the principal amount. The equity or the 7% interest is just designed to compensate him for the risk he took extending the amount, which is an interesting manner of repaying Mr. Wilt, and that's kind of unusual, but ultimately it doesn't factor in here because, as we've seen from Mr. Gibbs' email, they agreed to 7%. So what Mr. Gibbs agreed to was that they were going to repay, that the entities were going to repay those principal amounts plus 7% interest. The defendants bring up this issue of it's important to know who the investors are in these entities because it affects them, but that doesn't really go anywhere. The Espaces Knoxville is a sole member liability. It's a sole member LLC. The only member is Espaces Operations Inc. That's the same for Espaces Franklin. Espaces Operations Inc. has shareholders that are, it's Mr. Carmichael, Mr. Gibbs, Espaces Inc., and then another gentleman named Mr. Brian Fox. In terms of Espaces Inc., we asked Mr. Gibbs who are the shareholders, and he couldn't tell us, but he distinguished between outside shareholders and inside shareholders. The inside shareholders, again, Mr. Carmichael and Mr. Gibbs. We also have this issue of the exact payment due date, as we've seen, that's May 18th. The exact payment amounts, Mr. Wilt has specified that, and Mr. Gibbs has agreed that it's the principal amount plus 7% interest. And then we have this last day in the severance package, that's, again, May 22nd. But just taking a step back from all of this, I think one of the salient points is that in all of this, when Mr. Wilt was emailing Mr. Gibbs saying, why haven't you repaid us? Mr. Gibbs never said, well, we didn't agree on the parties, we didn't agree on the payment obligations, we didn't agree on due dates. He never said any of that. He simply said, we haven't repaid you because we don't have the money. And that's not a valid defense.
All right. Thank you, Mr. Bolso.
Thank you.
Mr. Knight?
Thank you, Your Honor. I want to go back to a couple of emails that Mr. Wilt talked to the court about and relied on. One of them has to do with the payment due date, which he says was May 18th. And the basis for that is Mr. Gibbs' email. Actually, I think it was the first email after the Jason's Deli meeting. And what Mr. Gibbs actually says in that email is, I expect funds to be available for this purpose by the end of the day, May 18th. It's not a promise. He expects that. He says, I will confirm. In other words, it's not certain. Later on, he may be able to confirm it, or let you know of any change. So that the funding date might change, not necessarily May 18th. So there's no way that that can be taken as an offer, acceptance, proposal of a May 18th contractual obligation to make the payment by May 18th. I expect it to be May 18th. That might change. The second email is what we've called the Gibbs email, which is the supposedly the acceptance of the terms, either memorialization of what they talked about at the Jason's Deli or acceptance of the terms in the Wilt Memorandum. So what does Mr. Gibbs say in that email? The first thing he says is, I'll call you later today, right? The parties are still negotiating terms. Here, Mr. Wilt makes a proposal. First thing Mr. Gibbs says is, I'll call you about this. The second thing he says is, and this is what they mainly rely on, the company's obligations will be addressed as you have outlined them. So we've got an outline. We've got, the idea is we're going to buy you out. That's what we intend to do. But does that mean he accepts the terms that Mr. Wilt has proposed? Definitely not. The next sentence says, I think May 22nd extends the process longer than it should take. In other words, you have to resign before May 22nd. Rejects that part of the proposal. If you think it will take that long, we can talk more about it. We're still negotiating. Maybe you can change my mind on that. Obviously not a finalized contract. And then the last sentence of the email, as I said yesterday, 60 days of salary continuation is not in the cards. Rejects another proposed term. So, this is not a finalized agreement. They had a framework. The parties agreed the best thing is for Espaces to buy out Mr. Wilt's investments, but it never got done. They never entered into a binding contract on that issue. Mr. Gibbs wanted to buy out Mr. Wilt's investments. He intended to have one of the companies buy out Mr. Wilt's investments, but he never entered into a binding contractual obligation to do that. Thank you.
Thank you, Mr. Knight and Mr. Bolso, for your arguments. We'll take your case under advisement. Call the next case, please.
Tennessee Farmers Mutual Insurance